We are back on the record. And 2023 CR 4371B, State versus Moreno-Vasquez. Can I have parties announced?
Megan Galway and Lorna Espinosa for the state.
David A. Garcia, attorney for Marco Moreno-Vasquez, Judge.
All right, and we do have an interpreter here. If you can state your name for the record, please, to the interpreter.
Mariana Rios.
All right. And she's previously been sworn. The deputy has informed me that a verdict has been reached in this trial. Are both parties ready to receive the verdict?
Yes, sir.
We are, Judge.
All right, Deputy Laura, are the jurors ready? All right, let's bring them in.
All right, for the jury.
All right, ladies and everyone, please be seated. Ladies and gentlemen of the jury, it's the court's understanding that you've reached a verdict in this case. Is that correct?
We have, Your Honor.
And is that a verdict as to each count?
Yes, ma'am.
And are those verdicts unanimous?
Yes, ma'am.
All right, if you'll hand the verdict form to the deputy, please. All right. If the defendant will please rise. Count one, to the charge of murder, it states, we, the jury, find the defendant, Marco Moreno-Vasquez, guilty of the offense of murder as charged in count one of the indictment. Count two, deadly conduct. It states, we, the jury, find the defendant, Marco Moreno-Vasquez, guilty of the offense of deadly conduct as charged in count two of the indictment. You may be seated. Does anyone wish to have the jury polled?
Not the state, Your Honor.
We do, Judge.
All right, ladies and gentlemen, I'm going to ask you if this is your verdict in counts one and counts two. If this is your verdict in counts one and count two, I'm going to need for you to respond yes. Does everyone understand? All right, so we'll start at the end here and then we'll go to the back. Is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict?
Yes.
All right, we'll start on the back row. And of course, the two alternates, you were not a part of the deliberation, so we'll start here. Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? All right, so ladies and gentlemen, what I'm going to do is I'm gonna have the deputy take you back to the jury room. There are a couple of things that I need to address before we bring you back out. Do not think about this trial again unless you're in the box, all right? Everyone, please rise for the jurors. All right, everyone, you may be seated. State, with regards to punishment, are you planning on having any witnesses?
No, Judge.
Defense, are you planning on having any witnesses?
Judge, the one witness that we called to be here is not here. We don't expect him to show up. So I need to speak to my client to see if he wants to testify.
All right. We'll give you a chance to do that. Is the courtroom next door available? Because he may want to speak to his client in private.
Yes, it is.
All right, so you can speak to your client next door with the interpreter.
Thank you, Judge.
All right, you're welcome. Thank you. Just give me 1 second. Let me print this out. There's something coming on the printer. All right, so there are 6 copies that are coming.
Make sure it's.
All right, and to the people, I'm looking for a children's book that I had growing up. All I remember is it was about a boy named Mark Park who walked in the dark. Because it's a children's book to rhyme to help children learn their words.
Wasn't Shel Silverstein where the sidewalk ends? I don't remember that one.
No, I don't think it was that one. But he has on one of those little beanie caps with the twirlers on top. And he wears a suit. The suit is striped.
You know what the shortest poem in history is, Judge?
What?
It's entitled Fleas, and the body of the poem is Adam had him.
Well, you know what the shortest verse in the Bible is? So this is my mom told me. My mom said, when they would go to church in the country, sometimes you'd have to have a Bible verse that you had to memorize. And she had forgot to do it. And so she said, my grandmother told her, oh, Jesus wept. And so she went to church and she stood up and, young children, right? She said, Jesus wept, and it brought the house down. Cindy, you have cousins and Jesus wept. I'm so impressed by you. Jason Wolf, who do you have and what is happening with your case?
Judge, I have Jonathan Lizardo.
Let me see
State
what
his
page he's on.
He's not on the docket, Your Honor. He was the one this morning, that didn't make it to the docket, but was on the spreadsheet.
Was in your notes for today's segment.
Yes. Okay, so let me pull this up, just 1 second.
Oh, wait. Oh, it's a rejection.
The ones on the, like, you're looking at it, the right are indicted, the other ones are the PIA, Mike Mag.
Oh, okay. Disco acknowledgements on him. Thank you.
All right, so you guys are set for jury trial.
Yes, Your Honor, I'm dismissing the case. The victims were canted yesterday.
See? Now, if I would have put this off for another day, like if I would have said, oh, all right, everybody, we'll be back in 45 days. Thank you.
Well, Mr. Wolf, as soon as it happens.
Well, thank you very much for doing that.
Me. Get all the-
All right, Mr. Charis, who do you have?
Got an inmate, Judge? Isaac Bias?
I'm sorry, who?
Isaac Bias? It's an MTR.
Okay. And Deputy Laura, are you able to knock next door and see if they're ready to come back?
Oh, it was-
Cases in Axon, they got all.
It's one of those like, there were two cases and they're just like, fuck it, we'll just put them in both
cases
hands.
are
I love it.
submitted. Like, you can see. like,
And state, so that I can put it in the system on the dismissal, what is your reason that you're checking off?
It'll be for a missing witness.
All right, thank
Yes,
you.
sir.
In the courtroom?
And defense, do you have any objection to the dismissal for missing witness?
No, Your Honor.
Okay. Are they? Oh, okay.
And then you'll make a copy of that for the phone,
Mhm.
please.
Of course. Which case is this on?
This is like that. I'm sorry.
Uh,
drug,
The
drug,
number,
one,
oh, the drugs? 8371.
sorry.
No problem.
Oh, it's real or make believe? See, now he's doing that believe so me, Jason. Let me see. Real. Because I'm trying to get that book. I need to know if that's the story that's in it. Yeah, I don't see how to get that. They're claiming they only have it in thrift books.
Approach.
Yes. I'm gonna have to find that book. But Sean, if you see that book anywhere, let me know.
What's the cause number? Oh,
It has a story in it, Mark Park. That was the name. Yeah, He's the boy who walked in the dog,
The defendant?
Cardo Adame.
but only in the park. And so all the school children are called him Mark Park
You have a few
because
seconds.
people were not watching their children.
Ricardo Adames. Thank you. So it was very much like.
Yeah. Oh, wait a minute. Let me
Truth.
see. I hope I didn't put this under the wrong number.
Yeah, concurrent, and then he's gonna have a bunch of misdemeanors ASAP.
There you are.
Ma'am.
Right,
Because
thank
he's
you.
claiming he wants his treatment,
Yeah.
so I'll give him on
Mm.
that, see if he follows through with two. So one's a drug, one's a theft. Thank you.
What do you mean? Mhm. That's what I'm here for.
All right, Norma?
So I just need. It's fine. If you'll sign the spots.
Yes.
On that, you'll elect a better word, sign spot.
All
Don't
right.
read, just sign.
And where can I find this book?
And then I'm gonna. People.
Yes.
Boy, he likes to walk, but just in the park. All the boys come to Marsh Park. He likes to walk, but just in the park, just in the dark. All the girls come to Marsh Park, walk in the dark.
Yes. So I'm trying to find that book.
And then we can just leave it with the.
Is
spot.
it- Okay.
I'm about to print the lab.
Got
And
discovery.
I'm about to do the shit.
Stipulations.
I'm printing the drug report right now.
Drug report. Oh, that's right.
Oh, who is the book by?
Sounds like some Shel Silverstein writing or something.
Maple O'Donnell,
Mm,
1966. You can find it on eBay.
Okay, so you say it's Mabel?
And a bunch of stuff.
Go for it.
It's called Real and Maple Leaf.
Is it ALD? The last name?
Oh, and then,
That's like the
I
last
have-
thing.
Okay.
Pages of the offense report
Yeah.
in hand.
I'm about to print the top.
Very good. You, I was about to say, I just took the offense report and the lab.
I use with like the items. And like there.
There is no question.
Then.
No, go ahead. It's all on, this is what I put early on Odyssey, like, it's all on.
You are. Okay.
Great. So much.
What page is that on?
Jason, two-thirds. I think. And the resistance.
Just give me a moment.
And we just attach all this together?
Yeah, for the lab. And then
All
the
right.
office report
Oh,
is
did
lab
you
report.
text it or? Text?
I'm sorry.
All right,
Offense
thank
report?
you.
Office
Lab.
report. Give me that one.
No, this is the press guide. Okay.
Okay.
Mhm.
Where's the actual?
Director of Offense Report, stand by, please. No, 9 pages of offense.
All right, so counsel,
So at this time, Judge, I've conferred with the state where my client has agreed to go to you for punishment, but I believe the state's not willing at this point. So we'll have to go before the jury.
yes. All right,
We're ready.
so we'll put that on the record. Cindy, are you ready? All right, so we're on the record in Marco Moreno-Vasquez. And I do believe, counsel, that before jury selection, your client elected to go to the jury for punishment if he were found guilty.
That's correct, Judge.
And you're asking that that be changed to the court?
After conferring with my client, which I've been trying to do for quite a while, as far as changing it, he has finally decided to go to the court.
And state,
Judge, at this time, we're not in agreement with that, based on the jury selection and the jury being under the impression that they're going to assess punishment.
all right. And state, you've stated before that you have no witnesses. Defense, are you going to have witnesses?
We do not, Judge.
All right, then we'll bring the jury in. Have both parties had a chance to review the charge? And what I can tell everyone, it's a basic charge.
I could just have,
Sure.
just a minute, Judge, I'm sorry.
You guys gonna use a,
And so attorneys, we're going to take up the closing arguments. It should be brief. And then the deputies will be able to bring your clients up and we will take care of that matters. but please give some time back if you are able to. All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what's called the charge of court on punishment. Again, you do not have to memorize this. The original will be given to you when you begin your deliberations. Charge of the court on punishment. Members of the jury, by your verdicts in this case, you have found the defendant, Marco Moreno-Vasquez, guilty of the offense of murder as charged in counts 1 of the indictment and deadly conduct as charged in count 2 of the indictment. It is necessary that the jury assess the punishment for these offenses. You are instructed that the punishment for murder, oh, I am so sorry. Please disregard everything I have just told you. State, would you like to make an opening statement?
No, Your Honor, we waive it.
Defense,
No, Your Honor.
state, any witnesses?
No, Judge, we just re-offer all of the evidence that was admitted in the trial.
No objection.
All right, and any witnesses from the defense?
No witnesses, Judge.
All right, thank you. So ladies and gentlemen, you can tell outside your presence, both parties had informed me that they did not intend to call witnesses. But both parties have now rested and closed as it relates to punishment. Now I can read to you the jury charge. Okay. Members of the jury, by your verdicts in this case, you have found the defendant, Marco Moreno-Vasquez, guilty of the offense of murder as charged in count 1 of the indictment and deadly conduct as charged in count 2 of the indictment. It is necessary that the jury assess the punishment for these offenses. You are instructed that the punishment for murder is confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. Therefore, you will assess the punishment of the defendant at life or any term of not more than 99 years or less than 5 years for count 1. You are instructed that the punishment for deadly conduct is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 10 years or less than 2 years. Therefore, you will assess the punishment of the defendant for any term of not more than 10 years or less than 2 years for count 2. In addition to imprisonment, an individual found guilty of the offense of murder and deadly conduct may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim or victims, if any, but is paid into the registry of the court. With regard to count 2, the defendant in this case has applied on written sworn motion for community supervision, stating among other things that he has never been convicted of a felony in this or any other state. Our statutes provide that where a defendant is found guilty of deadly conduct is charged in count 2 of the indictment, and the jury finds that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision on count 2, it will be granted by the court. If there is any evidence before you that the defendant may have committed any act of misconduct other than the offense of which you have convicted him, you are instructed that you may use that evidence, if any, in assessing punishment in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such other act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act of misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, and any system of averages or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the applicable law in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts if you should care to use them. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. Each party will have at least 15 minutes to speak to you on punishment. State, are you prepared to proceed?
Yes, Your Honor.
Ladies and gentlemen, we proceeded to the second phase of trial. During this phase, like the first, you will have the charge of the court. This shows the charge of the punishment. So here, in count 1 is murder. The range of punishment is anywhere from 5 to 99 years in prison. For count 2, that is a 3rd-degree felony, and the range of punishment is 2 to 10 years. Or in this case, you may assess probation. Now, at the end of defense's closing argument on punishment, Ms. Galloway will get up and ask you what the state seeks.
All right. Defense.
Thank you, Judge. Good afternoon. So we're back now on punishment. And most people don't understand the way the law applies to punishment. So you've heard on the 1st-degree case, the murder, that it's from 5 to 99. Okay, there's no probation on that. You get to choose between 5 and 99. That's why when we were selecting you, we had to make sure you could look at the entire range. Some people were going to be on the high end only. Some people were going to be on the low end only. So we had to make sure that you 12 could look at the entire range from the low to the high, to be fair to both sides. Now, as Marco sits there, he and I do not agree with your verdict, but we respect your verdict. We knew coming in that he had put himself between a rock and a hard place on some very serious charges. But that was done once he opened his mouth and spoke to those detectives and didn't say the right thing. He should have told them that he was in fear for his life and he was being threatened by ADIS. Not only him, but his wife and his children. Okay. You clearly didn't agree with that version, but nonetheless, that's where he is. And now we're before you based on the facts that were before you in this trial. So remember, he still holds that he's innocent even though you have convicted him. He's now a convicted murderer and convicted of the 3rd-degree felony of deadly conduct. And he respects your decision. We just don't agree with it. Okay? but we have to go forward and seek punishment now. So regarding the 5 to 99 and the 2 to 10, you get to choose, as the prosecutor, the judge have told you, and the charge makes it very clear. If you want to give them probation on the deadly conduct, you can. Probation only goes up to 10 years. That's the maximum for probation. But the real question is, what do you want to do with him on the murder charge? Okay, because somebody died here. Can't take that lightly. We never have. It's a horrible situation. But by the same token, you haven't heard any evidence about the victim, and I'm not bad-mouthing the victim here. Please understand. I'm just talking about the situation that we all find ourselves in. Okay, so regarding punishment, understand that it's 99 or life at the max. Most people don't understand that 60 to 99 years is exactly the same thing. So life is considered 60. So really, you're deciding between 5 and 60 years. Okay, on most felonies that are not considered aggravated, the time that a defendant, somebody who's convicted and sentenced to prison, does probably a quarter of the time. Okay, that's not the case here. Murder is considered an aggravated offense. So whatever you sentence him to, he will have to do half the time. Let me repeat that. Whatever you sentence him to, he will have to do half the time before he is eligible for parole. Remember, the word there is eligible. Doesn't mean he will necessarily get it. The Board of Pardons and Paroles makes that decision. Some people get it, some people don't. Depends on how they do in prison and what the charge is and what their previous is, their previous convictions, their previous arrest history. Here, you've heard nothing. So I can tell you that Marco had never been charged or convicted of any crime before this case. I can tell you.
Judge, I'm gonna object, and can we please approach?
Yes.
Sure.
And I'll pause your time.
Thank you. Where am I at?
You are at 10:54.
Okay. Let me clarify that. He's never been convicted of a felony in any county ever. Okay? So had he been, they would have brought that to you. They brought you nothing. Okay? So we have this case, which is still very serious. Nobody is diminishing that or minimizing that. Okay? So where I was on an aggravated offense like murder, a person will have to do half the time before they are eligible. I only tell you that because a lot of people get confused and then they send questions to the court asking what exactly everything means. So I think knowing that, that's pretty clear. So really you're looking at 2 to 60 years as far as punishment, as far as actual numbers. Okay, so you get to decide what to give him on the murder and on the deadly conduct. He's been in this country over 20 years, working construction in his little farm / ranch. Otherwise, he had had no problems until ADIS came into his life, which was unfortunate for him and his family. He's got a wife and 3 children, ages 8, daughter, a boy who's 16, and a daughter who's 17. These were the people that he was so worried about regarding this whole case. So I don't say this to forgive him because a life was still taken, but I want you to understand where he's coming. So regarding the range of punishment, some prosecutors, and I've been doing this a long time, both in New York and here. So some prosecutors will look at the range of punishment and they'll say, you know, normally what I do is I start in the middle. Okay, so if you start in the middle, it's not 2 and 99, it's 2 and 60. So that's what, 58 years. And I cut it in the middle. So 58 years divided by 2, I used to be really good at math. 60 would be 30, so we're looking at what, 38 years? No, that's not right. 30 years would be 60. So like 28 years and a half or something, 28 years? 29 years, around there. So they say we start in the middle and then we look at the defendant's past, his history. And if he's done bad things in his life, we move that up. And if he's done good things in his life, we move it down. Here you've heard nothing regarding any prior bad acts as far as convicted felonies, shootings, anything like that other than this case. And remember, I'm not diminishing or minimizing these charges because they're very serious. But this is what you have to deal with. So using that chart, and I'm not saying that these prosecutors are going to do that, but that's what most do. And so on that case, we would be moving him down from 28 years. Okay? Now understand, you also heard from Adis, who I submit to you is a cold-blooded killer. They're probably going to say, so is Marco. Look at Marco, he's not a cold-blooded killer. Remember Adis sitting up there who couldn't look at you? Did you see that face? I mean, I could look at him from my years of experience and tell that guy's a killer. Look at this guy. He's just not that bright. He's not that mean. He put himself in a really bad position, and here we are. And I appreciate all the time that you spent thinking about this case and giving him his day in court. Regarding the punishment, you know, Adis took a plea to a cap of 38 years. What that means is he's going to come back before this judge. And I hope they call me to testify so I can get up here and talk about his lies. But nonetheless, the judge knows. She heard all the testimony. So she's going to have to sentence him from 5 to 38 years. Okay, 5 to 35 years, I'm sorry. And decide what to do with him. I suggest you think about that when you think about Marco. And I brought you evidence that Marco was not the shooter, was not the killer of Danielle. Adis was. Marco was just the stooge, the patsy that Adis brought to you, brought to the incident, to the killing scene. So I would hope that you'd give him some leniency there. But that's your domain. You get to decide. That's why this system is the best, because you are his peers. And by the grace of God, you hope that you and your family members and somebody you know that's a good person doesn't get put in this situation. That a jury of 12 will look and understand the situation he was in, for better or worse. He clearly made a lot of bad decisions that day, probably by even letting Adis come work for him. But somebody's dead now. You have to decide what you want to do. Regarding the probation on count 2, that's completely up to you. You want to give him 10 years probation on the deadly conduct? You want to sentence him to 2 to 10 years? That's fine. But on the murder, it's 5 to 99 or really 60. So I hope that you will understand he didn't want to testify, because just like initially he wanted to testify in guilt innocence to scream out his innocence, we felt that the evidence was enough not to convict him. Now, when he could get before you and beg for mercy, he's decided that no matter what he says, it's not going to change the situation he's in. Whether he asks you for mercy, whether he tells you he didn't do it, I'm doing that for him. I ask that you be merciful to him and give him every opportunity you can to continue to have a life so he can be there for his 3 children. Thank you for your time.
All right, State.
Ladies and gentlemen, by your verdict, you have found the defendant guilty of the offenses of murder and deadly conduct. And now I come before you and I'm going to tell you the range of punishment. Regarding count one, the range of punishment is anywhere from 5 to 99 years or life in prison. On count one, that charge is not eligible for probation. And regarding count one, I am asking that you sentence the defendant to anywhere between 35 to 45 years in prison. Regarding count two, the range of punishment for that is anywhere from 2 to 10 years, or as has previously been explained, you do have the option to sentence him to anywhere from 10 years or under, and suspend and probate his sentence to place him on community supervision. I'm going to ask you to deny his application for community supervision and sentence him to a term of 10 years in prison on count two. Now, it is true the defendant has not been convicted of any felony offenses, and so he is eligible for probation on count two only. But were you to award him this, what you would be saying is that his behavior is only worth 10 years or below, and to be released back out into our community. And what would that look like to let him back out in our community without paying for what he did for his action? Now I'm going to move on. In this punishment phase, you can consider all of the evidence that you received in the guilt innocence phase of this trial. And as he sits before you here today, his attorney has let you know that he rejects your verdict. And you all have rejected his claim of innocence based on all of the evidence that was presented to you all. And he stands here before you today asking for sympathy based on circumstances that he knew existed at the time that he decided to act in concert with Adis Hernandez Rivas and go and participate in the murder of Danielle Valadares Fernandez. He knew he had a wife, and he enlisted her to drive them to the location. He knew that he had 3 children at that time. And what did he do? Tell him, yeah, come on, y'all sit in the back seat and watch me go and discharge my firearm at and in the direction of the complainant. When you heard the testimony of Roxana, they stopped at Kimberly Lane after Dairy Queen. And he had every opportunity to tell his kids, you know what, get off here. There's been absolutely no evidence, no witness that can corroborate this claim. And I want to urge to you all that if the statements of counsel are not in harmony with the evidence that you've received, you're to disregard them. Okay, there is no evidence that can corroborate this alleged threat by Adis Hernandez Rivas. If you guys look at the video, and I'm sure you did, I asked you to look at it again, the video from 7718 Winsford Drive. I've already talked to you about the demeanor of this defendant and his body language. Compare that to the demeanor of Adis. Okay, he is standing outside of the gate in view of the camera, acting as a lookout until the defendant comes running out, and that is when he produces his firearm and shoots. And that's what he testified to you all. Now, we did talk about the existence of parole. You cannot accurately predict how it is going to be applied in this case, but just know that the defendant will be eligible to apply for parole at halftime. So whatever sentence or how many years you award him in prison, he will be eligible to apply at halftime. So ladies and gentlemen, I again ask you regarding count 1, I'm asking you if you believe, and I submit to you that we have proved beyond a reasonable doubt that this defendant was the mastermind behind this murder, then I ask that you sentence him to 45 years. If you believe that he had a lesser role than that, I ask you to sentence him to 35 years. And regarding count 2, I ask that you deny his application and sentence him to 10 years and award a $2,000 fine in each count. Thank you.
All right, ladies and gentlemen, you'll be taking to the back to begin your deliberations. Everyone, please rise for the jurors. Everyone, please be seated. All right, and for those of you who are here, just request your inmates from the deputy and we will take your matters up.
Should I take the exhibits back again, Judge?
Just state defense.
Back row is here.
Sí.
Te van a traer para atrás cuando
Yes.
el jurado en juicio viene para atrás. How did I do?
You sign this part, because we're not waiving
Mhm.
an appeal.
No, what ends up happening, you sign it, but you are waiving your appeal as far as it relates to anything that's not involving pretrial motions.
Right, it says, for those matters were
That's your
raised by
special
written,
chair.
which we did.
Indeed.
Those will not be waived because that's what the paragraph says. You still sign.
But no, it says I knowingly voluntarily waive the right, under one, which is written for trial motion.
Yes, if they're, so according to that, been told what they need to do. But we're not doing it.
Charles.
All right, Deputy Laura, I am going to find that book. Now I'm on a search.
I sent you the, where, find it, I think it's on eBay because it said people's up.
Yep, this is the book. This is so the book. It brings back memories.
It's pricey, but
Wait a minute, how much it? Cool.
Oh.
Ah, only one left in stock.
you might want to take it now, Judge, or I'm gonna beat you to it.
This is the discovery.
Okay, did you guys never read this book before? Are y'all too young?
Okay.
Real and make believe
Yeah,
book.
when he comes out, but I can't imagine the situation. He goes, "What?" No, I'm sorry. David says MTR points. MTR, there's a new number one of the section. So
That's right. Let me see where there's actually.
I don't see that Lynn's appointed on that, so we'll have to get Lindsay onto that. I don't know. The year. Somebody. I probably need to, Lindsay doesn't like the section. I think a good one, already. I rode that horse pretty hard.
Mine was where the sidewalk ends, that was my favorite.
Ah,
Michelle Silver's.
okay.
From Burbank, you go over to.
That's good, 529-505.
CMAC was second. It's assigned to case assessed.
Okay.
Doing from second, we want 90 days, it's about 5 days. On the floor, it's just Oh, yeah. it's right.
It would be the.
It says-
For now, for this.
That's all. No, they don't know.
Okay.
You get this man.
Yeah, but. There's a bus. Hold on.
All right.
Right.
Already done.
Okay.
Any questions, Judge?
All right, thank you. Did you have the interpreter come back down?
Great. Great.
What's it say?
Is it run through
Do the sentences for charge 1 and 2 run concurrently or stack on top of each other?
Oh, and I have my proposed answer.
Fill up the bottom row right here. Whichever.
You don't want to send it back within the discussion report?
No.
All right, and so we'll just wait for your client to come out. All right, anyone who's ready, just sign in.
You need a month. Yeah. Yours. Right?
Yeah.
Bashan,
Now,
we have a application. It's on Samuel Zamaripa. Court is calling 2026 CR 003085 State versus Samuel Zamaripa. Can I have parties announced for the record?
Rental bus for Mr. Zamaripa.
And are you Mr. Zamaripa?
Yes, ma'am.
Just 1 second, Odyssey. Counsel, you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mrs. Zamaripa, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mrs. Zamaripa, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine.
I understand.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Zamaripa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, yes, I did.
According to the plea, there's $1,000 fine to be probated. All right, just 1 second. Step aside. Who's talking to the inmates? Who is speaking with the inmate?
Right here.
Where? All right, you need to step outside the courtroom. You'll be called back in if you are needed as a witness, but you're excused.
Please wait outside.
All right, we're back on the record. So according to the plea, there's $1,000 fine to be probated. State is recommending deferred adjudication. They're taking in consideration 2026 CC 007642. Did you understand that as your plea?
Yeah.
State defense?
That is the police.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon. Did you understand?
Yes, I understand.
Counsel, any such motions?
There was, Your Honor.
And outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 100 hours community service restitution, the DOEP course, and regular UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, I understand.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer say exhibit number one, including all of its stuff.
No objections to the proffered evidence, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes, I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, after having gone over the motion to press, I think everything has been said in there. I think this is probably one of those one-off issues, Your Honor, but it just happened with 3 different factors in it. I do think Mr. Zamarripa will do everything he needs to do to be successful and finish out any kind of probation.
All right, just one moment, if you can step aside. We're back on the record in 2023 CR 4371B, State versus Marco Antonio Moreno-Vasquez. Parties announced, please.
Megan Galway and Moreno-Vasquez for state.
David A. Garcia, attorney for Marco Moreno-Vasquez.
And we have an interpreter here.
Yes, Your Honor.
Yes.
Lee Gabriel.
Thank you. All right, the court received the following question from the jurors. Do the sentences for charge 1 and charge 2 run concurrently or stack on top of each other? Have both parties had a chance to review the question?
Yes.
Yes, Your Honor.
And defense, have you had a chance to review the question with your client?
I Judge.
The court proposes the following answer. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objection from the state or the defense?
No objection.
No objection, Your Honor.
Any objection to sending the question and the answer back to the jurors?
No objection.
All right, we're back on the record in 2026 CR 003085, State versus Samuel Zamarripa. All right, are you employed?
Yes.
What do you do?
Well, I'm a driving instructor and own and operate my own business.
Why do people not know what the yield sign is for? Are you teaching them that?
I'm battling to teach them that, yes, ma'am.
And are you teaching them that you're supposed to use the signal
Mhm.
before you stop? It's not stop, then turn on your signal? I've been seeing a lot of that.
100 feet ahead of time, yes.
All right, so if somebody is in front of me doing that, I can rest assured you were not the instructor.
That's correct.
Okay. All right, there's $1,000 fine. It will be probated, regular reporting by Zoom or in person. Regular UAs, are we gonna have any problems with drug testing?
No.
Or positive UAs?
No.
All right, proof of employment within 30 days. No employment as a home healthcare provider or with minors. Do you have any children?
No.
Do you live by yourself?
Yes.
Take in consideration 2026 CR 007642. 2 years deferred adjudication. 100 hours of community service restitution. I'm going to require the DOEP course. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 2 months. Probation, is there anything else?
Okay.
Anything else you need from the court to be successful?
No, I already had.
All right, did you review the document? I am so sorry. Could you hand me the trial court certification back? Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it?
Yes, yes, I did.
All right. You have a limited right to appeal. That right to appeal is as it relates to your pretrial motions that the court heard and made a ruling upon. Do you understand?
Yes.
Good luck to you
Thank you.
and counsel. Here you are.
Thank you. Maybe she.
Yes.
Thank you.
And you'll just need to speak with probation.
Yes.
All right, who has Arnold stamps?
Present, Your Honor.
Probation, there's no application. Court is calling 2026 CR 002368 State versus Arnold Stamps. Could I have the parties announced for the record?
State,
Renee Munoz on behalf of Mr. Stamps.
And you're Mr. Stamps?
Yes, Ruth.
All right, let's go off the record for a moment. All right. So we're back on the record. Counsel, you received all discovery. Did you review it with your client?
That's correct, Judge. Yes.
Court will find that the state is in compliance with discovery. Mr. Stamp, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
The judge state moves to waive the punishment enhancement.
No objection.
Right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Ruth.
Your charge is possession of a controlled substance penalty group 1 less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Mr. Stamps, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes, ma'am.
According to your plea, the enhancement is waived. There is 25 days in the Bexar County Jail under 1244. There's a $500 fine. Time and money to run concurrently. Is that what y'all intended?
Yes.
Yes, Your Honor.
Okay. This is run concurrent with 2026 CC 011438. Did you understand that to be your plea?
Yes, ma'am.
Defense and state?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor, State of States Exhibit 1 and all attached.
No objection.
All right, did you review the waiver and, oh, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We ask the court to follow the negotiated plea bargain agreement. Mr. Stamps is aware that methamphetamine can be a quite volatile substance, cut with fentanyl, other dangerous substances. He knows that continuing to mess with that is going to lead to trouble within the legal system. And I'm going to give him resources that once he is released, he can go ahead and seek that help from the reentry center, lifetime recovery, and or opportunity recovery. Judge.
Thank you. And who is Jennifer Thomason? Do you know her?
That was, I believe that was the lady that he was with at the park.
Okay.
But Mr. Stamps, did you have a relationship with that lady? No. No, it was someone you met then at the park that day. Yeah.
All right, do you have a place to live once you're released?
Yes.
Do you have family here in town, a support system?
No, ma'am.
All right, where's your
What
family?
I do, I have a daughter, my daughter is being sheriff.
Okay. Any other family members?
No, ma'am.
Are you originally from San Antonio or somewhere else?
Carrollville, Texas.
I'm sorry, where?
Carrollville,
Kerrville.
yes, ma'am, country.
Hmm.
The rest is dead. I'm the oldest, 75 years old.
Oh, wow.
Yes,
Well, that means that God has more things he wants you to do.
yes, ma'am. I
So
know.
you're gonna have to get your body right, okay?
Yes, ma'am.
All right, the court is gonna sentence you to a $500 fine, time and money to run concurrent. This is run concurrent with 2026 CC 011438. 25 days in the Bear County Jail under 1244. There's to be no contact with Jennifer Irene Thomason, Thomason. And the court will show that the judgment is satisfied. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Yes,
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
yes, ma'am.
All right, so here's the thing, and I can say this because I'm in the same boat that you're in. I'm in the twilight of my life. You're in the twilight of your life. Now, mind you, hey, you may end up being like Abraham from the Bible, getting your 200 years, or Methuselah getting, a lot of years. Maybe not. But the time that we have left on the planet, we shouldn't be destroying our bodies, right?
Yes, ma'am.
There are plenty of places, and I know your attorneys probably told you about them, that can help you with housing, help you with your addictions. When you're released from custody, if you don't know where else to go, you can come here during business hours. If I'm sitting here, I'll get you help, okay?
Yes, ma'am. Thank you.
All right, good luck to you. They'll probably be releasing you at 1 a.m.
He-
Why? I don't know.
He does have the misdemeanors cases, Judge, but they're set tomorrow.
Okay,
So upon those being extinguished, I believe he'll be processed. Judge.
all right.
Thank you. You're right.
Good luck to you.
I
What
appreciate
those
it.
other cases?
They're out of County Court number 9. I notified the misdemeanor I can double check right now.
Please do.
I will.
I'm gonna take it downstairs.
Thank you, ma'am, Your Honor, very much. God
Oh, you're
bless you.
welcome.
Yes, ma'am.
God bless you too. Do better, okay?
I will, most
Try to
definitely.
fight the
It's
addiction.
over. Never come back again.
Okay,
Thank you.
you're welcome.
Come on, Mr. Stamp. If you want, I'll put them on hold for you. If you wanna go check.
Please.
Anyone else ready?
Zachary Simmons.
All right, and Deputy Laura Cortez is coming back on Thursday. Cortez, he's on page 10.
It's Shelley Council for for.
All right, I'm sorry, so do you have Mr. Cox? Yes,
Okay.
you were on the list, correct?
Yes, ma'am.
Who do you have?
Zachary Simmons. Keep trying to say Zachary Taylor, Zachary Simmons.
Okay. Does anyone see Zachary Simmons?
Oh,
Say
you're
that.
right.
Tell you
Zachary
I
Simmons.
won't tell you.
He's right there. He's in a box.
Oh, I'm trying to find him on the,
Oh,
all right, thank you.
I ordered. a
Oh, and Deputy Laura, put Montoya, he's on page 8 for Thursday as well.
Because I know you want that.
Sorry, Mr. Cox, just give me one moment.
Montoya, thought about Princess Bride.
Inconceivable.
Came on TV the other night.
Is Alfonso not gonna be able to make it?
No, he won't be here.
Okay, I believe I have one on page 1 that says,
Okay. Oh, no, page 6.
page 1.
Okay, let me put that in here. Yeah, I don't think you're using that word correctly. Inconceivable.
Oh.
All right, and Deputy Laura, also Malara on page 1. All right, and so your client is,
Zachary Simmons.
all right, Zachary Simmons.
Well, no,
Morning, Your Honor.
Barney, how are you doing?
Sober and alive.
Oh, see, that is great. You know, you see things clear when you're sober.
Yes, ma'am.
I've been reading this book about this guy. And his brother is telling him, you know, the fun and games are over. You haven't been seeing things clearly. And so he decided to become sober. And he's like, oh my gosh, I am seeing things more clearly than I've ever seen before. So sometimes it takes a while.
The first time I tried methamphetamine, I was 9 years old. The person that killed my mom was a dope cook. And I mean, I'm not trying to throw a guilt trip, but I've been addicted to it my whole life. And I was hanging around with people. I've made bad choices in my life. And one of the bad choices I made was being around this individual. No.
This is not there. That's not mine.
Yes.
That's how it's cleaned up on honest.
Oh,
Because.
All right.
So the one thing I've learned is to being sober is being able to take accountability. And I made a bad choice that day. And
Well, I don't know if your
yeah,
attorney wants you
yes.
to get
Yeah,
into
okay, okay.
certain things.
I just wanted my time to be honest. Okay.
Yeah, not yet.
Okay.
Not for that.
Okay,
Not to
okay.
be honest,
Yeah.
but not.
Okay, okay.
All right, and I'll tell you what you've told me. You know, I've internalized it, but if it's not on the record, and if your attorney wants me to erase that from my mind, I can easily erase it from
Okay,
my
I'm
mind.
just another person, just trying to be real.
Oh no, I appreciate the realness.
Yes, ma'am. My old lady's a big fan of yours online.
Oh, what is that song, Kania saw? The R&B song, "Got to Be Real."
Got to be weird.
All right, so this has been set previously for a jury trial, but previously we were in a jury trial on State versus Rios. So are you still going to be requesting a jury, Mr. Cox?
Well,
Because he has two charges.
there's
on
two
him.
charges, Judge, and the only issue at this point is that
there's some evidence that's in the jail that we need to get. And the problem with it is that the jail may have deleted it. And what the state or informant, what they'll do is that they'll subpoena the persons that's over the jail mail or the correspondence. So we can have them do a search.
What are y'all looking for?
There's a letter that's written, we feel that may exonerate.
All right, written from.
By the victim.
Okay.
And it may exonerate my client from at least one charge.
And
So
is that the ag assault?
that's correct.
I'll take accountability for, I mean, all right.
Mr. Cox, let me know about the potential existence of this letter. I've initiated serving him a subpoena for correspondence from her to him within that date range, if it exists.
What's the date range?
October 2025.
October 15th, to be specific.
Yeah.
I'm gonna do the whole month.
You can do a whole one.
Okay, cool. Sorry, I'm not trying to interrupt. Took me 10 months to get here.
So y'all already calling the jail and see if they can get that for you now?
That'd be great.
You can do that,
Can we?
Greg?
All right, just step back. Let me see.
Okay.
What I need from you all.
Thank you, Judge.
You're welcome. Anyone else ready? Who's here on Morehouse?
I am Judge.
What is happening with Morehouse?
I was trying to figure that out. She has a violation report on, she picked up a criminal trespass case out of county court here.
Okay.
And, it was put on the docket for a compliance hearing here. I'm gonna see if we can work something out on the new case and.
Oh, well, if you all confer on the
and work
possession,
out
then
a
I'll pick it up.
package. Yeah,
Okay.
I'm waiting on them to make it.
All right, thank you. Okay, here's the thing. Just have a seat. Your attorney will talk to the state and then you all can approach me. All right. Anyone else ready? I hope I didn't miss. Okay, who?
Cooper. MTR on page.
All right, Eric Cooper.
wonder where family violence went.
Oh,
It's little Willie.
I don't know.
Where's old little Willie?
All right. Okay, I'll call you back when they come back.
He was just here.
Yeah. All right, Mr. Cox, they're gonna call me back. All right, anyone else ready?
No.
Okay. Hello.
Moreno-Vasquez, Judge,
Which page is that on?
page 3 of 15. Melissa's on that.
Wait, yes.
So I've talked to the state. They don't have their file. It just got transferred over.
Okay.
And I don't have a problem meeting with him on behalf of Melissa, but he is, I guess he's a cardinal or something.
Okay.
So,
Right. So what we'll do, you all will need to confer off, John, wait. All right. If you all can come around this way, state and defense. Set for discovery on Bruce Trio. Okay.
And a thousand things. That would be like 700 things. Every case I have.
Oh, okay.
I'm gonna go track it off. Okay. You need me, come get me. No.
All right.
I got a couple of aces I haven't played yet if you need them. Mine.
Morehouse,
Not late.
Just got involved with it, Judge.
okay. And what page is Morehouse on?
She's on the last page.
All right. No, not the last page.
Well, you might have gotten a new page. That's the last page.
All right.
Page 7.
Thank you. Oh, state, where are we on discovery on Morehouse? Have you received all discovery, counsel?
No, just
What's outstanding?
not sure.
Judge, if I may have a moment on this one to confer and see if there's any discovery that is missing. I don't believe there is any.
I don't know.
I haven't looked at the case.
The only reason I was here today was on a violation of.
All right, if you'll review it, tender an offer, and then I'll give you all a new copy.
Of course, Judge.
All right, thank you.
I have a question, Judge. Yeah, I am through.
I'm sorry, just one moment.
I do have one question, Judge. I did do on this previous case, I already did 35 to 30, almost 30 days in jail.
All right, so this is what I can tell you, what you're charged with. And I'm just looking on the docket. I haven't seen the indictment. The range of punishment is anywhere from 2 to 10 years in the prison and potentially probation. So I haven't reviewed anything. Your attorney will be able to speak with you. So he's going to confer with the state briefly, then I'll bring you back up, all right?
Yes, ma'am.
All right, thank you. Who's next?
What about Cooper? She got reset?
No, he hasn't conferred with the state.
Next is Eric, Mr. Judge.
All right, are you all ready on Mr. Cooper?
Have a seat.
They say it's family violence. Mr. Blanc is,
I'm here.
are you all ready? Are you all conferring?
We're ready. Mr. Cooper, we're
Yes.
prepared. Now we will.
And are you all proceeding on each motion?
We are, Your Honor.
All right, counsel, I don't have trial court certification.
We're continuing him.
I don't know.
Our agreement is for him to go to ISF to get treatment.
Yeah, I have to do the trial court certification, then I'll make a decision
Okay,
on if I'm gonna follow it.
let me do this.
Have a seat, Mr. Cooper. Thank you.
Violation number 4, yes.
Anyone else ready?
Could we?
Yes,
Morehouse.
yes. Ms. Morehouse, come down. All right, counsel, have you had a chance to confer with the state?
Yes, Judge. State needs a little time to be able to put together an offer. Said he'll have it to me by the end of the day.
All right, and state, does defense have all the discovery?
I acknowledge, yes, sir.
I'll check.
All right, Norma, recall this in 30 days for plea deadline date. All right, you'll be back on August 20th.
Thank you, Judge.
You know what, Norma? I'm sorry, put this on August 17th. All right, you'll be back on August 17th. And Deputy Laura, everybody who's coming over from custody on August 17th needs to be dressed for trial.
This is a fellow. And very nice. So you can make them.
All right, and on Jonathan Pomerantz, defense counsel's in jury trial, so Deputy Laura, you can send Pomerantz back. Jonathan Pomerantz.
Okay, and I picked her up to come back on August 3rd.
All right, state on Jonathan Pomerantz.
Yes.
Are you all asking for that to come back on August 3rd? Oh, sorry. Just one moment, everyone. So what we'll do, come down, sir. All right, they're telling me that they will have everything for you by Thursday, that they'll have it. Either it's gonna be there, it's not. And somebody will search the system.
They said it's purged, sorry to interrupt. They said it's purged from their system after 180 days. I don't know. It's
We're gonna see.
okay. Yes,
If it's
I
gonna
really
be there
hope.
or not, you know. So I'm gonna, Norma, recall him back for Thursday.
Thank you, Judge.
Oh, Simmons?
Yes,
Yes.
and we'll see if it's there.
All right.
Thank
Thank
you,
you.
Judge.
Thank you for your time.
Great, you're welcome.
All right.
All right, on Pomerantz,
Yes, we're asking for it.
August 3rd.
I think that'll work.
All right, Norma set it for August 3rd. And Simmons is on Thursday.
Ready, Mr. Simmons? Let's go.
You're welcome.
Wait, so I have one bird.
Just give me a moment.
I know like this little piece of when you listen to it.
Okay.
I know I think one of my spots. Sir. Okay.
Get it back. Who's your attorney?
I'm here.
I'm talking to another inmate.
All right, so people in the box, you're not allowed to talk to each other. You have to do that through inmate to inmate mail. This is what I'm telling you what I know. There are only two things that somebody who's in the same situation as you can tell you that you can take to the bank and they'll give you funds for it. One, how much time people are actually doing before they get parole. And two, when is everybody else catching chain? Usually the rest of it, you can't count on it as true. Does everybody understand? And because you all are here, your attorneys can speak to you. Sure. Robert Rodriguez, page 5, fourth context. Robert Rodriguez. All right. On this case, all discovery tendered.
Yes, sir.
There is a at-large assault family violence. It's a waiting filing, so I just emailed the intake ADA to review. That way I can extend the law.
All right, Norma, I need a reset for 30 days for a plea deadline date. All right, we'll see you back on August 20th. Thank you.
Okay. You put me on the list then when you're ready for him?
Yeah.
Okay. Brandon, my paperwork fixed on car. Yeah, it is fixed. Is it over here now? It's over there. Ricardo.
All right, who's here on Isaac Valle? And Charles, I'll just call you up when you finish with everybody.
Okay. Let's see.
Court is calling 2025 CR 003-678 State versus Isaac Joel Valle. Can I have parties announced?
Megan Galloway for the state.
Albert Chitis for Mr. Valle.
And are you Mr. Valle?
Yes, ma'am.
And are you all ready to proceed on the motion?
Yes, Your Honor.
We are.
Mr. Valle, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Isaac Joel Valle who was placed on deferred adjudication in 2025 CR 003-678 for the offense of evading arrest or detention with a vehicle on July 10th, 2025 for 6 years?
Yes, ma'am.
All right, state.
A violation of condition number 41 on or about the 6th day of July 2026 in Bear County, Texas. The defendant Isaac Joel Valle did then and there fail to comply with the rules and regulations of the felony drug court, and that the defendant entered an establishment whose primary purpose is to sell alcohol in violation of condition number 41.
How do you plead to that?
True.
All right.
We waive and abandon the remainder.
Any objections to the waivers?
No objections.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true with violation of condition 41?
Yes, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Judge, the proposed agreement is to alter and amend the defendant's condition for him to complete safety with aftercare.
And that is our agreement, Judge.
And probation?
Judge, the recommendation that's listed on the court summary is state ISF positive track followed by ISP. However, when he was in drug court, they held safety and state ISF in abeyance. Safety, if the court is inclined to go forth, is fine with me.
All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Isaac Joel Valle.
Yeah.
What's happening?
Isaac Joel Valle.
No, I mean, I understand your name. What's happening? Why are you not successful? Why are you going into, and I'm assuming you went into an ice house or a bar or something?
Yes, Your Honor.
Why are you doing that?
I had lost a friend to a stabbing a couple weeks before, and I was taking it kind of hard.
Why didn't you tell that to the people in felony drug court? Because they will help you address those issues.
Because I wasn't able to see them for like 2 weeks. Because I mean, I could have went.
No, let's not do that, because I'm not able to see them for 2 weeks, because mind you, I was an attorney in felony drug court. In felony drug court, when people come in as clients, they have you scheduled for every single day.
Right.
And that's one of the programs. You have everybody's cell phone number to call. So don't do, I wasn't able to see them for 2 weeks. So we're gonna start over and pretend like you didn't say that to me, okay?
Yes, ma'am.
So why didn't you call them and contact them to tell them, hey, my friend just got stabbed and I've lost my friend and I'm having issues coping with that?
It didn't come to mind for me to use my resources.
I mean, that's what they teach you when you're first in there.
When I was first in drug court, I went to Lifetime Recovery. That's
Mhm.
where I learned all my resources.
And then you come right back out, and I'm disregarding the one that says he used alcohol. But you come right out and disregard everything that you've been taught. That's a problem.
Right.
And I'm going to give you two choices. These are your choices. You don't have any other choice. Number one, I will revoke you. I'll sentence you to 3 years in the prison. Number two, I'll continue you and I will do state ISF cognitive track, followed by ISP, and a referral back to felony drug court. Those are your choices.
Yes, ma'am.
Well, which do you prefer?
Choice number 2.
All right. Thank you, state. So this is what the court will do. The court will deny the motion, alternate amend conditions to include the following. He's to remain in custody for transfer to ISF cognitive,
Just wait.
and then a re-referral to felony drug court. And Ms. Abrams, you can see if maybe they'll accept, they won't. Ah. So ISF cognitive followed by ISP. And did we ever do a gang evaluation on him?
I didn't have that listed as a.
All right, we're gonna do a gang evaluation, and that can be in custody as well. And then upon release, the UA hotline for 2 months with weekly testing. Probation, is there anything else? Is there anything else you need from the court?
No, Your Honor.
All right, thank you. Good luck to you.
Thank you, Your Honor.
Yes. Oh, we have a verdict, okay. Let's, Norman, can you get, yeah, because the taking of the verdict won't take that long.
I'll put everybody in the
Yes.
middle. Everybody in the box, stand up. Are you done? What you
Yes.
getting, probation?
Oh, he needs to have probation sign conditions.
Right, we'll put him in the back while we do the verdict. Come on up. Cause I gotta bring the guy out.
All right, we're on the record in 2023 CR 4371B. State versus Marco Moreno-Vasquez. Could I have parties announced?
Galvin, Lord of Rutherford State.
David A. Garcia, attorney for Marco Moreno-Vasquez, Judge.
All right, and we have the interpreter present.
Cesar Chavez, license number 2203.
All right, thank you. Let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen, we have an interpreter here. You've seen him here before. He has taken the oath to translate as well. It's the court's understanding that you all have reached a verdict as to punishment. Is that correct?
Yes, Your Honor.
And is that a verdict on each count? And is it unanimous? All right, if you'll hand the verdict form to Deputy Laura, please. Thank you. All right, if the defendant will please rise. And count one, it states, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. That's 40. In addition, we assess a $1,500 fine. And count two, it states, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 6 years. In addition, we assess a $1,500 fine and that the defendant's application for community supervision be denied. Is there anyone who wishes to poll the jury?
We do, Judge.
All right, you may be seated. Ladies and gentlemen, to each count, I'm going to ask you if this is your verdict. If this is your verdict, I need you to respond yes. Does everyone understand? All right, we'll start from the end. Is this your verdict? Yeah. Is this your verdict? Yes. Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
All right. In the back, is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
All right, ladies and gentlemen, Deputy Laura will take you back to the jury room and I'll come and speak with you briefly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Moreno-Vasquez, the jury having found you guilty, the court is finding you guilty in counts 1 and counts 2. And the jury's verdict of 40 years in count 1 with a $1,500 fine and 6 years in count 2 with a $1,500 fine. The court will enter those as your sentence as well. And count 1 and count 2 will run concurrently. And in count 1, there's an affirmative finding of deadly weapon. And let me see, could I see the indictment as it relates to count 2, please? Ah, thank you. I'll have it there, yeah. No, I was, because you were bringing it. Thank you.
That's count 3 marked out.
All right. Is there anything else with regards to sentencing from either side?
No, Your Honor.
All right. Mr. Vasquez, did you review the trial court certification of defendant's rights to appeal with your attorney?
Yeah, they told me it was for appealing, yes.
All right. And counsel, do you speak Spanish fluently?
I do, Judge.
And have you been able to communicate with your client with and without an interpreter?
I have, Judge.
All right. Then with regards to the trial court certification of defendant's rights to appeal, Mr. Moreno-Vasquez, because this was not a plea bargaining case in a jury trial, you do have the right to appeal. All right, is there anything else from either side?
Not from the defense, Judge, but if we can keep the interpreter here just for a little longer, I'll have my client sign a motion for an appeal.
All right, thank you.
We can do Cooper, Judge, I guess, whenever you want.
All right.
I've given that to the probation to read, and then I'll give it back if you need to read it again.
Yes, I'll need to read it because I haven't read it.
Just, what's our downstairs though?
Yes, let me see, who is here? The attorneys who are not here. All right, what is happening with Oscar Carvajal?
Please, paperwork turned in.
Okay. Yes. Oh, okay, let me see. All right, so Carvajal is going to be a plea. That's what y'all are saying?
Yes, I am saying.
Okay.
Yeah.
And then on Juan Mejia,
Look out for you.
okay. And then Ricardo Adames,
Please, paperwork turned in.
okay. And then Sabrano,
Please, paperwork turned in.
okay. All right, and then Max Perez.
I haven't heard from, chapter judge.
All right, recall that for the 23rd.
You can. Just can.
And then Al Cosell,
Judge. Depends on the thing, if you can just point for Thursday.
all right, we'll recall it for Thursday. And then Morehouse, what day did we call that back for?
You said, he's asking for the 17th, like his other client. the
Okay.
female.
All right, the 17th. Bring her dressed.
Okay. That you have,
Morehouse. And then Charles Pena with Mick Aguilera.
That's the one that was reassigned to Charles Buck.
Okay.
He's up there.
All right, and you're working on Charles Pena?
Right now, yes.
Okay. And then Geraldo Castillo.
That's gonna be a plea.
All right.
Can I click off it's a plea bargain?
Oh, I do that. All right, Robert Galvan with Zachary Green.
I sent the text judge, I don't know for that.
He came in and then he left. He's recall that for Thursday. He's on page 8, Deputy Laura.
Thank you, Judge.
And then Joe Cantu on page 11.
That's Thursday, Judge.
All right, Thursday.
That's it.
Dominique Smith.
Adrian Bettis is in, trial in Florida.
All right, recall that, for the first week in August, what day?
I can do August 3rd.
All right, Deputy Laura, Dominique Smith on page 12 is August 3rd. James Price.
Robert Bettis.
Yes.
I have Robert Bettis.
All right, recall that for Thursday. Victor Mesa, that's Lindsay Shaw.
And that's being taken care of by John there.
Okay. Then we have, okay, that's Eric Cooper. All righty. Yes, yes. That's what I said. Yeah. Okay.
Been a busy day.
Yes, ma'am.
Oh, yes.
All right, who do you need to reset on?
Just Mr. Pena, I just got appointed today. I have looked at the discovery briefly. I had given him the initial offer, but we have a lot of work to do.
Which time are you asking?
30 days?
Norma, a 30-day reset on Pena.
August 20th.
Sure.
That for discovery, Judge?
We'll put it down as discovery.
Yes, okay. With Charles. August 20th.
All right, are y'all ready on Cooper?
Yes. Yes.
Court is calling 2024 CR 008984 and 2024 CR 5691, State versus Eric Lee Cooper. Can I have parties announced?
Will Van Ziegler for the state of Texas.
Charles Buck for Mr. Cooper.
And are you Mr. Cooper?
Yes, ma'am.
All right. Did you review the motions to revoke community supervision with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Eric Cooper who was placed on community supervision in 2024 CR 008984 and 2024 CR 5691?
Yes, ma'am.
All right, state.
Yes, Your Honor, the state will be proceeding on the 2 violations of condition number 4 in each motion.
Okay. Can I have the file stamp for probation over there, please? Oh, Norma's grabbing it. Mhm. All right, you may proceed.
Yes, Your Honor. Violated condition number 4. In Bear County, Texas, the defendant, Eric Lee Cooper Jr., did then and there fail to report to the supervision officer, was directed for the months of January, February, March 2026, in violation of condition number 4.
How do you plead to that, true or not true?
True. Additionally, Your Honor, the defendant violated condition number 4 in Bear County, Texas. The defendant, Eric Lee Cooper Jr., did then fail to report to the supervision officer as directed for the month of December 2025, in violation of condition number 4.
How do you plead to that?
That's in both cases, Your Honor. The state will waive the remaining violations.
All right, and with regards, and I will, of course, disregard the violations, but for purposes,
Yes, Your Honor.
what is happening with these?
In terms of the family violence cases, I'm going to direct the misdemeanor prosecutor to reject them in recognition of this motion to revoke. We have never established contact with the victim in that case, despite multiple attempts over several months. She's simply beyond our reach.
All right, and with regards to the possession case?
Your Honor, the possession.
Been dismissed already, there before a separate contested NPR.
All right. All right, did you understand by pleading true to violation of condition number 4 and 4 in each cause number, the court could find you guilty and sentence you up to 5 years in the prison and cause number ending in 84
Yes, ma'am.
and up to 2 years and the cause number ending in 91?
Yes.
Knowing that, do you still wish to plead true to 4 and 4 in each cause number? In each cause number, the court will find 4 and 4 true. Is there a proposed agreement?
Yes, Your Honor, the probation department at this time is recommending that the conditions be amended to include safe, intermediate sanctions facility, substance abuse track, followed by aftercare. I guess their presumption that this defendant has a substance abuse problem.
Wait, are you saying safe or SATA?
SATIF, I apologize.
Oh, no problem.
No, IS,
Or
yeah,
ISF, intermediate
ISF.
sanction facility. I apologize.
State ISF.
All right. And so I've read your letter. So why should I follow this agreement? And let me tell you why I'm asking that. I'm asking that because this is the second time you've been before the court for a violation of condition number 4. So I need someone to explain to me why you shouldn't go to prison.
I'll let you go first if you'd like.
So,
If you want me to talk to her, I will. I mean, I know if you want to talk to her, just talk to her.
so
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Cooper.
All right, so why shouldn't I just send you to prison? Because it appears to the court that maybe that's where you want to be. And when I say that, of course, nobody wants to go to prison, but I just go by actions, right?
Yes, ma'am.
All right, yes.
Honestly, I don't want to go to prison. I'm not trying to end myself in there, but I was in an abusive relationship. So where I was crying out for help, trying to get away from the abusive. But
Abusive relationship. And what is this person's name?
Ariana,
I'm sorry, what?
Ariana
Ariana what?
Sullivan,
All right, continue.
I was trying to cry out for help, asking probation to see if I can go to a halfway house or a shelter. They wasn't trying to let me go there or anywhere else. They were just threatening me with jail time. So
All right, are you saying that you reached out
to my probation
to
officer.
probation?
Yes.
All right, does anybody have proof of this? Probation,
Yes, Judge.
do you have any proof that he reached out to probation stating that he was in an abusive relationship?
Judge, I would need a moment to review the file.
Okay, she's gonna review the file. Continue telling me what else.
Yeah. I wanted to get away. I didn't want to continue to be at that household, continue to get abused on. So I took matters into my own hands when I shouldn't have, just up and left.
Yeah, but I don't understand the cutting off of the GPS. Because to me, if you're just gonna leave, you just leave and you leave with GPS on and probation will know where you are. So you cut off the GPS, then what happened?
I just left.
But he did contact immediately, shortly after the removal of the device, he contacted probation on his own.
All right, and so,
So he did stay in contact. I mean, I know it sounds interesting. It's documented that he contacted them after the removal of the device.
all right, so according to this, the GPS monitor, he removed it on November 26, 2025.
Correct.
When did he contact?
And I believe it says January of 26. He reached out to probation,
That's a full
trying
month.
to find help. Now, when was it?
What, April 30th.
Okay, and then on top of everything else, Judge, at the end of April of this year, he was at home with his newborn, and the newborn passed away in its sleep. So that's also, I believe that at the ISF facility, he can get some mental health help also, because he's really struggling with that. He's been in jail now for almost 3 months.
All right, and who's the mother of that child?
Jasmine, my credit.
And she was present this morning and she wanted to be here today, but she got called back to work.
Okay.
So she's present. That there is an autopsy that's being done. The results aren't back yet. that's something that is also weighing very, very heavily on him. He's been in jail, unable to mourn with the mother of the child or anyone really almost since it happened, almost since it happened. So I'm hopeful that he can get the ISF from the court and get some help, not just for the other issues that clearly need to be addressed, but also this issue that's been newly sprung upon him. That safe to say?
Yes,
Okay.
So when did his child pass?
April 30th,
And when were you arrested?
same night.
Yeah.
And have services taken place?
Yes, they have.
And were you available to be at the services or no?
I was trying to get your permission, but nobody from the jail would contact you, I guess. I don't know how it worked.
All right.
Your Honor.
Yes.
With regard to that infant, there's a potential case being investigated regarding that. There's no information about it at this time. That case was presented later. That's not being contemplated by this
All right, there's
agreement or MTR or any of that. That would be a future.
absolutely, anytime an infant dies in someone's care, there's an investigation. So, but it is certainly the understanding of myself, my client, that case is not involved in this agreement in any way, shape, or form. And if something was to arise, he would be forced to deal with that independently. So I think that's what the state's going to make sure that it's clear that we don't think that, that case is being TIC'd or not that there is a case. We don't expect there ever will be. But in the event that there was, we understand it has nothing to do with what we're asking the court today.
All right, I'm gonna give you a choice. Number one, I can revoke you and I'll sentence you to 2 years in each cause number. They're running currently. You'll receive credit for any time that you've been in custody, or I'll continue. You're going to, they want you to go to state ISF followed by aftercare. Those are your two choices. Sure.
After you stay on probation and you get help back, once they release you from the program, you still continue to get counseling through probation.
And actually get an actual counselor.
Yes, they will help you get an actual counselor, yes. Oh, sorry, my son's on emergency back pass.
Ah. Which do you prefer?
ISF.
All right, in each cause number, the court is finding 4 and 4 true. The court will deny the motion. The court will follow the recommendation from probation and also the agreement of the state and the defense. And are you waiving your right to appeal?
Yes, ma'am.
The court is, in each cause number, is going to alter and amend conditions to include state state ISF, and then probation, if you can have him evaluated for any type of trauma therapy. Is there anything else you need from the court?
Would I be getting trauma therapy while I'm incarcerated? Right, like
You'll need to talk to them about that when you go there. And if there's some issue, just let me know.
Okay.
They will address that.
Address that right now?
I'm sorry?
Can I tell you about that right now?
Sure.
Okay, because I try to talk to mental health in jail. I write sick calls and all that. I get on the kiosk. I talk to classification, write grievances. I don't.
Oh,
Mental health doesn't.
Let me just tell you, we're going to make sure it's taken care of. That is why I always tell people, if you have an issue, you can come back to court and talk to me. I'm here 9 to 5, sometimes, well, really 8:30 to 5:30 or 6. And I tell people if there's some issues, come in and talk to me, and they don't. So I can't do anything if people don't let me know what's going on. Oh, yes.
Multi-evaluation was done in May, and they did not recommend any further testing.
Okay. All right, just do the trauma thing. Maybe he needs some trauma therapy. There we go. Is there anything else probation you recommend?
No.
All right, thank you.
Right, thank you. Thank you. Over you got that report. Yes, I've been on the road to get this stuff. Of course. Oh, Penya's already been reset. It's already been reset? No, let me think. Yes, Penya's already been reset. He's gone.
Your Honor, I believe that was the last family violence case. May I be excused?
Yes.
Thank you.
You're welcome.
Thanks for your help.
Sorry. Jesse Sambrano. Who's the attorney for thank you. Court is calling 2026 CR 005561 State versus Jesse Sambrano. Could I have parties announced for the record?
State.
Charles Buck for Mr. Sembrano.
You're Mr. Sambrano.
Yes.
Counsel, you received all discovery, reviewed it with your client?
I have, Judge, and just let the record reflect, I was appointed today. My client and myself are both willing to waive any time requirements, and we're ready to proceed today.
Is that correct?
Yes, ma'am.
All right, no gum chewing.
Slow.
Okay.
All right,
How about that?
and unfold the arms.
Yes, ma'am.
All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment?
Yes, ma'am.
Counsel, you do you waive the reading?
I do.
State proceeding as presented?
No, we're proceeding on the lesser included for attempted ECW.
Any objection?
No.
All right, probation there proceeding on attempted unlawfully carrying of a weapon with a felony conviction as a third-degree felony. Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the range of punishment is anywhere from 2 to 10 years in the prison, up to a $10,000 fine. If you have a plea, I don't have to follow it. If I don't and give you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, we have reviewed the discovery and gone over any possible defenses.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on the lesser included offense. Punishments be assessed at 4 years in the prison. There's a $1,000 fine that will be probated, and the state is recommending community supervision. Did you understand that to be your plea?
Yes, ma'am.
Defense and state?
Yes, sir.
Yes, Judge.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Outside the agreement, the state is recommending your community supervision be for a term of 4 years. I think I gave you the.
Yeah, I have it. Yes.
No, I gave you the wrong one.
I wondered, and I was looking at it like, what is that? Long day.
All right, 100 hours community service restitution, no possession of firearms or ammunition, no operating a motor vehicle without proof of valid license or an affidavit of non-driving. Did you understand those were their recommendations?
Yes, ma'am.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Please grant receipt of receipts exhibit 1 and all attached.
No objections.
All right, did you review the waiver and stipulations with your attorney? Understand it, sign it in all the appropriate places?
Yes, ma'am.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it into evidence and review the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty of the lesser included offense. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your
We
client?
believe he's worthy of the plea bargain. We ask you to follow it.
All right, are you employed?
Yes, ma'am.
What do you do?
I'm a tattoo artist.
Do you have any children?
Yes, ma'am. Actually, I have one.
I have a 1-year-old at home and a baby on the way.
Ah, hey. All right, this is what the court will do. Court is going to sentence you to 4 years in the prison, suspended and probated for 4 years, regular reporting by Zoom or in person, proof of employment within 45 days, no employment as a home health care provider or with minors. There's going to be 100 hours community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits one time for 2 months. There is to be a gang evaluation. No possession of firearms, which you're not allowed to possess firearms. This is a felony conviction. There's to be no driving without a valid license. Do you understand?
Yes, ma'am.
And you need to provide that to probation. And there's to be regular UAs. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am. I did.
All right, because it's plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Do head tattoos, the skull, does that hurt? Is that painful?
Yes, ma'am. I do.
Are you doing those tattoos now where people are put under and then they get the full body tattoo and they wake up?
I wish I could have done that myself, but no.
They say some people are having issues when they wake up from that, but all right. Good luck to you.
Thank you.
You're welcome.
Yes, ma'am.
Ricardo Adames. Ricardo Adames, come down.
With this one, Judge, we have a motion to amend the index that we filed and presented to the defense as well. Because I'm still working on 3 clicks.
All right, court is calling 2026 CR 008349 and 2026 CR 008371. State versus Ricardo Adames. Can I have parties announced?
Espinosa for the state.
Charles Bont for Mr. Adames.
And are you Mr. Adames?
Yes, ma'am.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We did.
State and the cause number ending in 49. Are you proceeding on the indictment as presented?
Yes, Judge, after the urging of state's motion to amend.
We don't
Yes.
object.
All right, any objection to the amendment? And counsel, you received all discovery and did you review it with your client?
Yes, Judge.
And in each cause number, the court will find that the state is in compliance with discovery. Oh, and I'm sorry, and 7-1, are you all proceeding on the indictment as presented or waiving?
We're waiving the enhancement.
Again, no objections.
Did you review the admonishments in each cause number?
Yes, Your Honor.
All right, in cause number ending in 7-1, you're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In the cause number ending in 4-1, you're charged with theft of property as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to do that?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Adamis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No one, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. It and sign it in both places.
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Understood.
Counsel, any such motions?
No, Judge.
Outside the agreement in each cause number, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 100 hours community service restitution, no contact with the academy, SATF, cognitive thinking, anti-theft course, DOEP, random UAs. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Understood, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments in both causes.
No objections.
In each cause number, did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony.
Understood, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Accepted to evidence States Exhibits 1 and attachments, and the court will review the same. Oh, State, you may be excused. All right, in each cause number, the court will find there's sufficient evidence to find you guilty. And in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, we believe the plea bargains were conferred after serious negotiations. We believe they're appropriate. We ask you to follow them. We understand that SATF is a possible condition, so if the court wants to order the TAP evaluation done in custody, in case that's the event, we certainly would understand.
All right, and the cause number 2026 CR 008371. Oh, no problem.
Ready.
Okay. All right, and that cause number, as previously stated, the court is finding you guilty. Court will sentence you to 6 years, suspended and probated for 5 years. Regular reporting by Zoom or in person. The UA hotline for 3 months with weekly testing. This is run concurrent with 2026 CR 008349. Proof of employment within 45 days of release no employment as a home health care provider or with minors. $120 restitution to the Bear County Crime Lab for drug testing. In custody, there's to be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow recommendations of TAP. 100 hours of community service restitution. Do you have children,
Adult children,
grandchildren?
grandchildren,
And what are their ages?
2.
All right. Parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Probation, is there anything else under that cause number? And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Understood, Your Honor.
All right, and cause number 2026 CR 008349. The court is going to find you guilty. Oh, state, I only had, maybe I'm missing it. Ah, here it is. And that cause number, the court is finding you guilty. Court is going to sentence you to the court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years, regular reporting by Zoom or in person, UA hotline for 3 months with weekly testing. This is to run concurrently with 2026 CR 008371. Proof of employment within 45 days, no employment as a home healthcare provider with minors. In custody, there's to be a TAP evaluation and referral to felony drug court. 100 hours of community service restitution. I'm going to order the anti-theft course, the felony and anti-theft course. Once that's completed, community service hours shall be deemed satisfied. Field visits 1 time per month until further notice. Taking consideration 2026 CR 008374 and 2026 CR 000313. There's to be no contact with Academy. Probation, is there anything else?
Number 3871, I'm sorry, on that one, would you say field visits 1 time a month until further notice?
Yes.
And that's all done.
All right, in this cause number, is there any restitution state? All right, again, in that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, Your
And
Honor.
sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. This is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Understood, Your Honor.
All right, good luck to you.
Thank you.
Have a seat.
Good luck to you.
Thank you.
We'll get you a copy. No, she only gave me the other one. She didn't
Oh, I
give me-
gave you 2. I gave you the first one, and then I didn't see the other one. Do you not have it?
Oh, I'm sorry, yes.
Okay, all right, thank you. Anyone else ready?
I have a gentleman in the box named Mr. Mesa. He's just, It's for a reset. He has an MTR, but he has a new sexual
Okay.
case.
All right, Mr. Mesa. What page is he on?
He's probably on the MTR page, Judge.
Oh. All right, Victor Mesa, what we'll do is we're gonna recall this. And we'll set it for contested in 45 days.
Okay, that's fine.
All right, Ms. Ferguson, I need a contested hearing date, 45 days. All right, and then counsel, if it's not going to be contested, if you'll let probation know 2 weeks out.
I certainly will.
All right, thank you.
September 8th, got it, okay. I'll be in touch, yes. Come on this way. Mesa, you can go. What is that?
All right, so we're just waiting on the paperwork on Carver Hall.
Got three more, please. Three more, please.
Okay.
And
And then that will be it, right?
yeah. Castillo in. Yeah.
Okay.
So. I do 30 minutes.
Oh, we're gonna make it happen.
Okay,
And who else, and you know what? Who else can't happen? The attorneys can appear by Zoom.
Huh?
Oh, they can appear by Zoom or something. I mean, if all their paper, no, I'm saying if their paperwork is done. And when I say appear by Zoom on another date, not today. All right, Carver Hall. Plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Judge,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Mr. Carver Hall, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, ma'am.
Anyone promise you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
In each cause, well, not in each cause number, in the aggravated robbery cases, according to your plea, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon, no applications. These cases will run concurrently. The state is taking several cases into consideration, including 2025 CR 011310B. In the state jail felony, your punishment is to be assessed at 391 days in the Bear County Jail with the judgment satisfied. Did you understand that to be your plea in each cause number?
Yes, ma'am.
Defense and state?
That is the plea, Judge. Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Judge.
State in 9B, you only have the affidavit.
Yes, that's all they included.
All right. Is there any objection to just proceeding on the affidavit and the
No.
court reviewing that?
No, I believe that's substantive.
Okay. All right. In each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer state exhibit number 1, including all attachments in all cases.
Any objection?
None.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, ma'am.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. That means that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1, and the court will review the same. And Norma, I need a reset date for a PSI.
September the 8th, Judge.
All right, September 8th. Okay. PSI on top? No, this is just.
Just
Bob,
PSI.
Do you need us to help you?
No, I do not.
Yep, just PSI. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. And the court will find you guilty. And in each cause number, even though the unauthorized use of a vehicle, I see that's a judgment satisfied. I'm going to bring back all cases on September 8th.
Yes, Judge.
And there's to be a PSI in each case.
Yes, Judge. Thank you.
Thank you.
Thank you.
For that.
She needs to be presented.
No, it saddens you, but I think that's all I have with you today.
No, you're leaving us. All right, you and Cornelius Cox are going to have to share that office that's in the back. We're going to put your names on it.
I was asked earlier on text if I brought a sleeping bag for today. So thank you, Judge.
You're welcome. Thank you so much. Oh, state,
Yes, Judge.
the cases that you're taking in consideration, you want to wait until sentencing?
That would be our preference.
Oh, sure. Juan Mejia. Is this an application?
No, Your Honor.
All right, court is calling 2026 CR 0000081. State versus Juan Mejia. Can I have parties announced?
Michael Collins, attorney for defendant, present and ready, Your Honor.
All right, and are you Juan Mejia?
Yes, ma'am.
Counsel, you received all the discovery. Did you review it with your client?
Yeah, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mejia, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do, Your Honor.
State, are you proceeding as presented?
We are, Judge.
Did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention in a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, and I believe he was, Your Honor.
Mr. Mejia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. This will run concurrently with,
Actually, it's 2 years TDC, Your Honor.
oh, that is so true. I'm so sorry. All right, 2 years TDC. You wouldn't want state jail felony time because that's day for day. 2 years TDC, concurrent with 2025 CC 006-987, 2025 PF 41243, 2025 PF 50734. Taking consideration 2025 PF 41242, 2026 CC 0000524, 2026 PF 25278. Did you understand that to be your plea?
Yes, ma'am.
State defense?
That is the plea, Judge.
That is our agreement, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No, contest.
State any evidence.
Judge, we offer you state exhibit number 1, including all attachments.
I've reviewed that with my client, Your Honor. We have no objections.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we'd ask that he get credit for time served that he has.
All right, the court will find you guilty, sentence you to 2 years in the prison, give you credit for any time served. This will run concurrently with the following 2025 cause numbers. 2025 CC 006987, PF 41243, PF 50734. Take in consideration the following numbers: 2025 PF 41242, the following 2026 cause numbers: CC 000524, PF 25278. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, do better. You're too young for this.
Yeah.
All right, good luck to you, okay? Geraldo Castillo.
Brandon, is that just the felony one? How do I get that one?
Court is calling 2026 CR 007863, State versus Geraldo Castillo Jr. Can I have parties announced?
Brandon Ferreira for the state.
And Richard Garcia for the defense. Ready, Your Honor?
And are you Mr. Castillo?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor, yes.
Court will find that the state is in compliance with discovery. Mr. Castillo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State proceeding as presented?
Judge will be proceeding solely on count one, waiving and abandoning count two and the enhancement.
Any objection?
No objections, Judge.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with manufacturing or deliver controlled substance, kilogram 1, 4,200 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to do that?
Yes, Your Honor.
Counsel, your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Castillo, anyone threaten you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed on count 1 at 9 years in the prison. Did you understand that to be your plea?
Yes, Your Honor.
State defense?
That is the plea, Judge.
Yes, Your Honor, that is the plea.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we are proceeding exhibit number 1, including all attachments.
No objections, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we are.
Anything you wish to say on behalf of your client?
No, Your Honor, we're just asking that you follow the plea bars.
All right, the court will sentence you to 9 years in the prison, give you credit for any time served. There's to be no residing in household with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I understand, Your Honor.
All right, make better decisions. Don't build your happiness off somebody else's misery. And when you're selling drugs, that's what you're doing, okay? All right, good luck to you.
Thank you, Judge.
Thank you.
Mrs. Reed, so she followed the plea bargain, you have no right. Okay. Good luck. Later.
Let's go to the left one. You sit right over there, to the left.
We survived. But see, what I'm doing in this court right now, it's preparing you all for the zombie apocalypse, because guess what? You don't know if the zombies are gonna run fast or if the zombies are gonna run slow.
Okay, thank you.
Oh, but here's the thing, you'll be able to continue. Yeah.
The stress management.
I'll do mental gymnastics.
Yeah. And we are actually signed off. I don't know why this computer is doing this strange thing.
Like, what is?
You know, there have been these videos that have been coming up. They make the zombie apocalypse seem so great because they show them they're running, and then all of a sudden this attractive guy is running against it with them. And then they go to this bunker. And in the bunker, I think they're Asian, because in the bunker, they're making noodles and they have all this food and it's storage. And I'm like, that's what I want for my bunker.
On The Last of Us, have you watched that show?
Yeah, I did. I
You need
watched
to
that
watch
one.
it if you like zombie stuff, because I don't even like zombie stuff and I watched it, but that's one thing. My plan to survive the zombie apocalypse is to manipulate a man into a safe area.
And you know what? It can be done, but you gotta make sure you get with the right person, because did you ever watch the Book of Eli?
No, I haven't.
Oh my gosh, you gotta see the Book of Eli. It's with Denzel Washington. It is so good. Then you'll realize, well, I just can't.
I have to rely on.
Doesn't it teach you like you need to learn how to read Braille?
Yep.
Oh, you gotta learn how to read Braille and everything else.
With everything else in here, just talk about. Should be your L7 to